Alex Murdaugh at 4147 Moselle Road. I need the police to answer immediately. My wife and child are shot badly.
This is your wife and son?
Did I kill my wife? Just no, Daddy.
It's just so bad. They did it so bad.
There's not one shred of evidence.
One question begets another, which begets another.
I go by Buster.
Do you have any idea who's done this?
Good afternoon. Greg Adeline reporting live outside the Colleton County Courthouse here in Walterboro as there is a break in the action in the Alex Murdaugh murder trial. Judge Newman is about to charge the jury as the jury is about to get ready to head into deliberations. We could have a verdict anytime after that. There's a lot of evidence to go over in this case, but the jurors will get behind closed doors and start to go over that evidence, but not before they are charged by Judge Newman, who is set to take the bench in just minutes from now. To give you a little bit of the lay of the land as to where we are in this case, closing arguments happened today. The defense taking their argument to that jury, talking about all of the ways in which their client is not guilty of murder, saying that reasonable doubt certainly exists in this case and poking holes in many ways into the investigation brought by SLED. They say that there were missed opportunities. In many ways, they say that the investigation was sloppy and that essentially what happened was they never eliminated Alex Murdaugh from that circle of interest, a circle of interest that they say was zeroed in on Alex Murdaugh from day one. Now, another important fact about Jim Griffin's closing argument was that he got emotional at times. At the end of his argument, talking, his voice shaking, crying to that jury, saying that Alex ran to his baby too. You remember a moment yesterday in Creighton Waters' closing argument when he talked about Maggie Murdaugh in a very human and very emotional way, saying that Maggie Murdaugh in her final moments was running to her baby. Jim Griffin turning that on its head today, saying that Alex Murdaugh was running to his baby too. Want to play that soundbite for you? It was one of the more emotional of Jim Griffin's entire argument that lasted probably about 2 hours long this morning. It was exhaustive in many ways, so many elements throughout his argument that there were different bits and pieces that he was throwing against the wall, just trying to plant that reasonable doubt, so critical in this case. But let's listen to him getting emotional, talking about Alex when he discovered the bodies as well.
You know, Mr. Waters gets up here and says, Maggie was running to her baby. Alex was running to his baby. And can you imagine what he saw? And is it evidence of guilt that he doesn't remember what the sequencing was in that moment? Is that evidence? Is that evidence of guilt? Or is that evidence of trauma? This is a guy that then went to get a 12-gauge shotgun and he put 16-gauge shells in it. He knows the difference, but he didn't know that night.
And so after that, the state had a chance to offer a rebuttal. It was a 40-minute rebuttal from John Meadors. John Meadors, one of the more theatrical, somewhat you could say a flamboyant lawyers on the state's team, and he has this thundering voice, and he gets into this cadence in which he is able to just kind of emphasize his certain points. There was a moment earlier in this trial when he was questioning Laura Rutland, who was a detective on the scene at Moselle on June the 7th, 2021. And it was this back and forth between Meadors with Laura Rutland that was one of the more powerful moments of this trial, in which he was ticking off instance after instance where Rutland said Alex Murdaugh was clean on the night of June the 7th or in the early morning hours of June the 8th. And Meadors went back and forth with Rutland saying, how were his hands? Clean. How were his arms? Clean. How were his legs? Clean. Could you please point out to the defendant, he said, is the defendant in this courtroom? And she pointed to Alex Murdaugh in what was somewhat of a Perry Mason moment, as was described in the trial at that time. Well, today, John Meadors did much of the same, saying that when it came to Alex Murdaugh, sure, he loved Maggie and Paul Murdaugh, but ultimately, in the end, as evidenced in the roadside shooting case, he loved himself more. That's what Meadors said, and that was the crux of his argument. He hit a lot of things in that rebuttal, just little cracks that he was able to kind of expose in some of the defense's closing argument even prior, talking about the dogs at the kennels, how they never sensed anybody there. That was one of the key things that came out of Alex Murdaugh's testimony, saying that in the moments before the murders, the dogs didn't sense any danger. Well, John Meadors said that essentially your best witness are the dogs. He said, where would we be right now in this trial if we didn't hear on a kennel video at 8:44 Alex Murdaugh yell, "Bubba," on that recording? Very powerful for this jury. Ultimately, Meadors hammering credibility and believability, saying that common sense must be taken back to that jury room. That is happening as soon as Judge Newman charges this jury in just moments from now. I want to bring in our legal analyst, Carl B. Grant. Carl, we saw a lot of fireworks this morning,
yes,
not only from Jim Griffin, but also from John Meadors. Again, it was that cadence. It was the way he kind of had that jury. Who do you think in the battle of these two litigators won the day?
Well, they're both great trial lawyers, no doubt about that. But when it comes to trial lawyers, everybody has their own style. You can't be somebody else. You have to be yourself and show that you're authentic when it comes to your argument. Now, my style is more of a Meadors kind of style, getting passionate with the jury and showing emotion, using your voice as a weapon, as I talked about earlier. So naturally, I'd be more like a Meadors kind of trial lawyer. I think that when it comes to deliberation, the jury's got a lot to decide. But because the issue now is one about mostly credibility, it might not take them that long. I remember many years ago, ironically, on this same station, when O.J. Simpson was tried, Dick Harpootlian was called and asked how long did he think it would take for the verdict to come back, and I think Dick predicted maybe a month. And I predicted about 3.5 hours.
Wow.
And that's exactly what it took, about 3.5 hours for the jury to come back and acquit O.J. Now, I'm not predicting any kind of particular verdict in this case, but I don't know how long it's going to take this jury, but I don't think it's going to take them as long as everybody is anticipating, considering the number of witnesses and the number of evidence and exhibits that they've admitted.
You know, that's a good point, Carl. The sense from some is that this may be a quick verdict here, and of course it takes a unanimous verdict. All it takes is one or two jurors to possibly have that reasonable doubt for it to be a hung jury, but we will likely know if it's a hung jury by the length of time that it takes for this jury to decide their verdict. You know, if it takes days upon days upon days, and Judge Newman has said that he's open to the fact that they might work through the weekend to come up with a verdict. Take us inside that jury room, Carl. You know, being such an experienced trial lawyer, what's it like in the effort, perhaps? Do you get the sense that maybe there's a pack of people who have made their minds up and a couple of, maybe one or two that may not have?
Well, that could be the case. But the thing is, everybody has to have an opportunity to have their say. And each juror's opinion has to be respected. That's the role of the foreman, to not be dogmatic in his or her opinions, but to treat everybody equally and give them an opportunity to be heard, and, of course, to collect the votes and report that vote to the judge. I believe that after they've looked at everything, they'll do the right thing. I really do believe that.
So, John Meadors, we want to get back to his presentation, that final rebuttal, where he was, in some ways, he does have a history with Dick Harpootlian. He has argued cases with Dick Harpootlian before, a murder case involving a lawyer years ago, in which Dick Harpootlian lost that case. So a couple of similar, I guess, maybe coming full circle in some ways between these two litigators' career. But John Meadors was saying, ultimately, his argument is that when it came down to it, Alex Murdaugh was concerned about nobody but himself, and not only committing these murders, he says, but also in creating a tale, lying about being at the kennels as well. Take a listen to that.
Ryan, I'm sorry, I lied about everything.
I was under a lot of pressure. Had a lot going on. Really? Your wife and your son were murdered 3 months ago. And now this is the real Alex. Well, my world's coming down. My world, Alex's world is coming down. Been confronted by his law partners. Losing his job. Now it's me. My world's being affected.
Jim Griffin earlier on had said that there was no motive in this case. And John Metters there, you can see rebutting that rather effectively. Want to get back into the courtroom here as we await this jury. A jury that has sat and listened to arguments now for 5.5 weeks. They went to Moselle yesterday. They got a look at that property that they've heard about ad nauseum. They've heard about so many pieces of evidence and so many scenarios, so many exhibits, but they got to see the Moselle property yesterday firsthand. They came back today to listen to the defense's closing argument. They heard Creighton Waters yesterday in his closing argument. And, of course, we had a juror that was dismissed earlier on. But let's listen to Judge Newman.
Received the evidence and heard the arguments of the state and the defendant. I will now explain to you the law that applies to this case. Under the Constitution and laws of South Carolina, you are the finders of the facts in this case. I do not have the right to pass upon the facts or to even express any opinion that I might have as to them, because this is a matter solely for you, the jury, to determine. As jurors, then, it is your duty to determine the effect, the value, and the weight of the evidence presented during this trial. As a trial judge, it is my responsibility to preside over the trial of the case, and I have the duty to rule upon or pass upon the admissibility of the evidence offered during the trial. You are to consider only the testimony which has been presented from this witness stand, along with other exhibits and evidence presented during the trial. Any other evidence or exhibits which have been made a part of the record you may consider, along with any stipulations made by counsel. I have the additional duty to charge you the law applicable to this case. And as the presiding judge, I am the sole judge of the law. It is your duty as jurors to accept and apply the law as I now state it to you, then to deliberate in an effort to reach your verdict. And finally, I charge you in this regard that you should not be concerned with what you think the law ought to be, but what I charge you that the law is. You are also the judges, the sole judges of the credibility, that is the believability of the witnesses who have testified and of the evidence offered. In considering credibility, you may take into consideration many things, such as the demeanor or manner of testifying, whether the witness had reason to be biased or prejudiced, and whether the testimony was contradicted on the one hand or supported and corroborated on the other hand. You may believe a small portion of a witness's testimony and disregard the larger, or vice versa. All these things you will consider, bearing in mind that you should give the defendant the benefit of any reasonable doubt. It becomes your duty as jurors to analyze and to evaluate the evidence and determine that evidence which convinces you of its truth. There are two types of evidence which are generally presented during a trial: direct evidence and circumstantial evidence. Direct evidence directly proves the existence of a fact and does not require deduction. Circumstantial evidence is proof of a chain of facts and circumstances indicating the existence of a fact. Crimes may be proven by direct evidence or circumstantial evidence. The law makes no distinction between the weight or value to be given either direct evidence or circumstantial evidence. However, to the extent the state relies on circumstantial evidence, the circumstances must be consistent with each other and, when taken together, point conclusively to the guilt of the accused beyond a reasonable doubt. If these circumstances merely portray the defendant's behavior as suspicious, the proof has failed. The state has the burden of proving the defendant guilty beyond a reasonable doubt. This burden rests with the state, regardless of whether the state relies on direct evidence, circumstantial evidence, or some combination of the two. The rules of evidence ordinarily do not permit witnesses to testify to opinions or conclusions. An exception to this rule exists for witnesses we call expert witnesses. An expert witness is a witness who, by education and experience, has become expert in some art, science, profession, or calling, and may state an opinion as to relevant and material matter in which the witness claims to be an expert, and may also state the reasons for the opinion. You should consider any expert opinion received in evidence, and like any other evidence, give it the weight you think it deserves. If you decide that the opinion of an expert is not based on sufficient education and experience, or if you conclude that the reasons given in support of the opinion are not sound, or that the opinion is outweighed by other evidence, you may then disregard the opinion entirely. An expert witness's testimony is to be given no greater weight than that of any other witness, simply because the witness is an expert. Further, you are not required to accept an expert's opinion, even though it is not contradicted. In regard to evidence of other crimes and evidence of alleged bad acts on other occasions, this evidence is limited to consideration by you as it relates to the motive of the defendant for the offenses charged in this case. This evidence cannot be used for any other purpose. This type of evidence must not be considered in any other fashion. In particular, the South Carolina rules of evidence provide that evidence of other crimes, wrongs, or acts is not admissible to prove the character of a person in order to show action in conformity therewith. Put another way, evidence of other crimes or bad acts cannot be used to show that the defendant is a bad person and therefore is more likely to have committed the crime for which he is accused. You may not consider evidence of other crimes and bad acts for this purpose or for any other purpose other than it as it relates to the motive of the defendant. In addition, while you may have heard that other crimes and bad acts of the defendant have resulted in other charges or indictments not before you, the fact that the defendant was arrested, charged, and indicted in these matters is not evidence. and cannot be considered by you as evidence of guilt in this case, nor do these indictments create any presumption of guilt. As to any other pending charges, as is the case here, the defendant is presumed innocent until proven guilty beyond a reasonable doubt by the state in a court of law. The function of the jury is to determine whether a defendant is guilty or not guilty, and the consequences of a conviction in this or other pending matters is of no aid in determining whether the defendant committed the offense. You should not consider nor speculate about sentencing consequences for this or any other crimes, as those issues are not before you. The fact that the defendant was arrested, charged, and indicted in this case is not evidence and cannot be considered by you as evidence of guilt. Nor does it create any presumption or inference of guilt. The indictments are simply the formal written instruments which contain the charges made against the defendant. The indictments are the formal documents by which this case is brought into this court. The defendant, Richard Alexander Murdaugh, has pled not guilty to the indictments, and that plea puts the burden on the state to prove the defendant guilty. A person charged with committing a criminal offense in South Carolina is never required to prove himself innocent. I charge you that it is an important rule of the law that the defendant in a criminal trial, no matter what the seriousness of the charge may be, will always be presumed to be innocent of the crime for which the indictment was issued, unless guilt has been proven by evidence satisfying you of that guilt beyond a reasonable doubt. This presumption of innocence does not end when you begin your deliberations, but it accompanies the defendant throughout the trial until you reach a verdict of guilt based on evidence satisfying you of that guilt beyond a reasonable doubt. The presumption of innocence is like a robe of righteousness placed about the shoulders of the defendant, which remains with the defendant until it has been stripped from the defendant by evidence satisfying you of that guilt beyond a reasonable doubt. The presumption of innocence is not a mere legal theory. It's not just a legal phrase. It is a substantial right to which every defendant is entitled, unless you, the jury, are satisfied from the evidence of the guilt of the defendant beyond a reasonable doubt. The state must prove the defendant guilty beyond a reasonable doubt. So what is a reasonable doubt in the law? A reasonable doubt is a doubt which makes an honest, reasonable, sincere, and conscientious juror hesitate to act. Proof beyond a reasonable doubt must therefore be proof of such a convincing character that a reasonable person would not hesitate to rely and act upon it in the most important of his or her own affairs. Proof beyond the reasonable doubt can also be described as proof that leaves you firmly convinced of the guilt of the defendant. Now, there are very few things in this world that we know with absolute certainty. And in criminal cases, the law does not require proof that overcomes every possible doubt. If based on your consideration of the evidence, you are firmly convinced that the defendant is guilty of a crime charged, you must then find him guilty. If, on the other hand, you think there's a real possibility that he is not guilty, you must then give him the benefit of the doubt and find him not guilty. The indictments in this case allege 4 separate offenses against the defendant. The indictments are murder of Maggie Murdaugh, murder of Paul Murdaugh, possession of a weapon during the commission of a violent crime involving the murder of Maggie Murdaugh, and possession of a weapon during the commission of a violent crime involving the murder of Paul Murdaugh. Each indictment charges a separate and distinct offense. You must decide each indictment separately on the evidence and the law applicable to it, uninfluenced by your decision as to any other indictment. The defendant may be convicted or acquitted on any or all of the offenses charged. You will be asked to write a separate verdict of guilty or not guilty for each indictment. The defendant, Richard Alexander Murdaugh, is charged with the murder of Margaret Murdaugh and Paul Murdaugh. The state must prove beyond a reasonable doubt that the defendant killed Margaret Murdaugh and Paul Murdaugh with malice aforethought. Malice is hatred, ill will, or hostility towards another person. It is the intentional doing of a wrongful act without just cause or excuse, and with an intent to inflict an injury, or under the circumstances that the law will infer an evil intent. Malice aforethought does not require that malice exists for any particular time before the act is committed, but malice must exist in the mind of the defendant just before and at the time the act is committed. Therefore, there must be a combination of the previous evil intent and the act. Malice aforethought may be expressed or inferred. These terms, expressed and inferred, do not mean different kinds of malice, but merely the manner in which malice may be shown to exist. That is, either by direct evidence or by inference from the facts and circumstances which are proven. Express malice is shown when a person speaks words which express hatred or ill will for another, or when the person prepared beforehand to do the act which was later accomplished. For example, lying in wait for a person or any other acts of preparation going to show that the deed was within the mind of the defendant would be expressed malice. Malice may be inferred from conduct showing a total disregard for human life. The defendant is also charged with possession of a weapon during the commission of a violent crime. 2 counts. The state must prove beyond a reasonable doubt that the defendant was in possession of a firearm during the commission of a violent crime. A firearm means any weapon which is designed to or may readily be converted to expel a projectile. In order to find the defendant guilty of possession of a weapon during the commission of a violent crime, you must first find the defendant guilty of committing a violent crime. Murder is a violent crime. The state must prove beyond a reasonable doubt that the weapon furthered, advanced, or helped in the commission of the crime. While the arguments of counsel are a beneficial part of every trial, you should remember that the statements made by counsel are not evidence. In presenting their arguments, counsel often have referred to the evidence. However, you should base your verdict on the evidence as you remember it. If there are any conflicts between the recollection of counsel about the evidence and your own recollection, you should rely on your own understanding of the evidence. You must decide whether the state has met its burden of proof beyond a reasonable doubt based solely on the evidence presented in this courtroom. As you were instructed at the start of the trial, you're not permitted to conduct any independent research about this case. The facts of the case, the evidence presented in the case, or the people or organizations involved in any way in the case. Do not try to find any information from any source outside the courtroom, however reliable that source may seem to be. Do not look at dictionaries or other reference materials. Search the internet, websites, or blogs, or use any other electronic tools to get information about this case or help you make a decision. You may not use computers, telephones, cell phones, smartphones, tablets, the internet, or other tools of technology with communication capabilities at any time during your deliberations, except only as provided by the court to review the digital evidence in this case. If your deliberations necessitate an overnight break, you may use these devices as necessary, but you may not use them to communicate with anyone about the case until the case is over. This means that you must not use phone calls, video calls, emails, text messages, instant messages, blogs, chat rooms, websites, or any social media, such as Facebook, Twitter, LinkedIn, YouTube, Reddit, and Discord, to send or receive any information about this case. This includes information about a party, a witness, an attorney, a court officer, or your fellow jurors. News accounts about the case, research on any topic raised, or even any topics you may think would be helpful in deciding the case, or any testimony presented by any witness you may not investigate. During your deliberations, do not read, listen to, or watch any news reports about this case. This includes anything that may be in the newspapers or on the internet, radio, or television. You must not consider anything you may have read or heard about the case outside of the courtroom, whether before or during the trial. Information on television, radio, internet, or from other sources may be wrong or incomplete. In our judicial system, it is important that you are not influenced by anything or anyone outside of this courtroom. If your deliberations necessitate an overnight break, even though you may use electronic devices as necessary for purposes unrelated to this trial, I must urge you to minimize your use of such devices. Many internet browsers, smartphone apps, and social media services as well as traditional media like television and radio, will provide information and news that you do not seek with little or no prompting. It is a strong possibility that information about this case may be thrust upon you every time you use an electronic device. You must therefore use these devices only as absolutely necessary. You must ignore and avoid uninvited information about this case. No matter, forelady and members of the jury, I am required to charge you the law as I have done through these instructions now I'm being given, to help guide you to a just and lawful verdict. Whether some of these instructions apply will depend upon what you find to be the facts. The fact that I have instructed you on various subjects must not be considered as indicating an opinion of this court as to what you should find to be the facts or what your verdict should be. In conclusion, now you've been chosen and sworn to give the parties a fair and impartial trial. When you have done so, you will have completed your oath, and no one will have a right to criticize your verdict. You must not be swayed or influenced by opinions or expressions of opinion you may have heard outside of the courtroom, but rather should base your verdict solely on the testimony of the sworn witnesses who took the stand, the exhibits received into evidence, and the law which I have stated. You should not be swayed by caprice, passion, prejudice, or improper sympathy for or against anyone. Remember, you have no friends to reward or enemies to punish, and all parties are entitled to a fair and impartial trial. It is your duty as jurors to consult with one another and to deliberate in an effort to reach an agreement. Each of you must decide this case for yourself, but only after impartial consideration of all of the evidence with your fellow jurors. In the course of your deliberations, do not hesitate to re-examine your own views and change your opinion if you become convinced it is erroneous. However, do not surrender your honest conviction as to the weight or effect of the evidence solely because of the opinion of your fellow jurors or for the mere purpose of returning a verdict. As I stated earlier, you are the judges of the facts. Your verdict must represent the considered judgment of each juror. In other words, your verdict must be unanimous. Now, you may have noticed that I have read these instructions. I do so to give you the law as accurately as possible. I will give you a copy of these instructions to have in the jury room. You may refer to these instructions to assist you in your deliberations. You must consider the instructions as a whole and not follow some and ignore others. And Madam Forelady, it will be your duty to preside over the deliberations of the jury. If during your deliberations you should desire to communicate with the court, please reduce your message or question to writing, signed by your foreperson and the foreperson only. Do not address any questions to anyone other than the court, and reduce it to writing and pass it to the bailiff signed by the foreperson and the foreperson only. It will then be brought to my attention. I will then respond as promptly as possible, either in writing or by having you return to the courtroom. I caution you, however, with regard to any message or question you might send, that you should never state or specify your numerical division at the time. Now, you've heard the testimony and you have heard the law. Whatever your verdict, Madam Forelady, you will indicate the verdict on the back of each indictment and then sign and date your verdict. You will have these 4 indictments, and on the back of each indictment is a place for verdict. And as to each one, you'll write your verdict, either not guilty or guilty, then sign and date the verdict. You're not authorized to write the verdict until all of you have agreed on the verdict. Now, in just a minute, I will send you to the jury room. But prior to doing so, I want to ensure that from the 12 jurors we have remaining, if there is any reason that any one of you cannot continue deliberating, please let me know at this time. We have 13 jurors. Only 12 can deliberate. So out of the first 12 jurors now on the panel, if there are any reasons why you cannot continue, please let me know at this time before I excuse the alternate. A show of hands as to anyone who cannot continue deliberating. All right. All jurors then seem to be in good shape and good to go. So when the jury leaves the courtroom, the alternate will remain. And the alternate is. I will send you to the jury room, all of you, except for the alternate. But do not begin deliberations until you have received a copy of this jury charge, the indictments, and the exhibits. Once you receive these things, that will be your signal to begin your deliberations. Once you begin deliberations, you will deliberate until you have reached a verdict, at which time you will knock on the door, advise the bailiff, and we will bring you out to receive your verdict. So if all of you will now go to the jury room except for the alternate, juror number 741, who will remain with us while the others go to the jury room.